So I have to work, and I'm working on my case against the British government, and I thought I'd just give you an update on how things are going. So things aren't fabulous. They're not going fabulously um, for the moment. I'm not completely out of the game as yet, but for one thing, the defendants have not responded to the complaint, and they are now in default. And so the question is, what do I do about that? Okay, but that's the first step. Really, my biggest opponent right now is the actual database for the court called the CMECF database. I mean, every single thing I upload to this database gets kicked back as an error that I have to refile because I've put it in the wrong place. So that's one thing. So you've put everything in the wrong place. Everything is in the wrong place. Okay. The other thing is, so I've done 2 motions so far. One is to certify the case as a class action so that I'm representing myself, and I'm also representing anyone else who is of Caribbean ancestry, who does not know their actual origins, which country in Africa they actually came from, and who would like to know that. And so I've asked the court to have the defendants pay for DNA tests for anyone who is so injured where they don't know their origins. My position is that, as an American, I have a fundamental right to know my origins, and I don't know my origins because of the commercial activities of the defendant government and monarchy of the United Kingdom, right? These commercial activities were called, quote unquote, the transatlantic slave trade. And as a consequence of the transatlantic slave trade, there have been direct effects on my life. And that is, I don't know my origins. I think it's a pretty clear case, but I don't think the court is particularly convinced. So anyway, she has basically, or I should say the court has denied my motion to certify the case as a class action. And the reason she gave is that I can't represent third parties because I'm one of the parties in the case, which I guess is not a totally unreasonable position to take. But my position is that according to the other cases that I have read on this issue, the main concern that the courts have had is that attorneys who are pro se, that is, who are representing themselves, should not represent other parties in a class action because there's a conflict of interest, because those attorneys will receive attorney's fees if they win the case. And so the conflict of interest is, why are you bringing this case? Is it because you believe in this case, or is it because of the money that you will make from the case if you win? So I have basically said to the court, don't pay me any money. Don't pay me even a penny on this case. I don't want any attorney's fees on this case. I want to handle this case because I believe it is both legally and ethically proper that the defendants pay for these DNA tests. The court has not yet answered that, so that's pending. But there was another motion that I filed that the judge also denied. And, it's a little bit more complicated. And I have asked to appeal that motion, as well as the denial of class action certification. And I guess they will allow me to appeal the second motion. I'm not sure if they're going to allow me to appeal the class action certification, which, if they don't, kind of defeats my whole case, doesn't it? So we have to see what the judge decides there. And the other thing, and I guess the only good thing, is they're allowing me to move forward without paying the court fees. So they're allowing me to move forward in forma pauperis, which means that I'm basically a pauper. I'm too poor to pay the court fees. So that's really good, because in fact, I'm too poor to pay the court fees. I basically can't even eat at this point. So I can't pay court fees. These are a lot of, these court fees are just ridiculously huge. So there's that. So I've got 14 days, I guess, after today to file the appeal on those two motions to the Second Circuit in New York. So that's kind of like intimidating. I mean, I've never filed an appeal before in my life, and I haven't even appeared before this court. I mean, the Southern District of New York is a very serious court. I mean, that's where President Trump is being, is going to be tried for, he's going to go through a trial for the Stormy Daniels, whatever her name is, hush money payments to this woman, during the election, whatever. So this is a very serious court, and I've never appeared before this court before. There are many nevers. There are many firsts here. I've never used ECF. I've never appeared before the Southern District or any district court. Now I have to file an appeal or two appeals in a higher court from the Southern District of New York. Never did that before. And if I lose there, which is, they're going to take one look at this ECF record of everything being kicked back, and I have to refile everything, and they're going to make a decision just based on that. So I am not optimistic about my chances in the Second Circuit, just because, I think many things count against me. I think one thing is that I am not an attorney in, an expensive law firm. I can't walk into the court in a man's body with my suit and my briefcase and my two other strong men with me who come from my law firm, and I just look really imposing, and the judge is immediately going to respect me, especially because she looks at my ECF and she sees everything as impeccable because I've been doing this for 25 years. What they see when I walk in there is someone who's never done this, who is, I don't look imposing, you see how I behave like a teenager, and they're not going to have the same, I don't think that I'm going to have the same, it's just not going to be the same. I'm not going to be looked upon in the same way as if I were, some 50-year-old man who owns a law firm on Park Avenue in Manhattan, and has been practicing law in the district courts for 25 years. It's just not going to happen. Okay. So what am I saying? I'm saying that I'm working on my appeal, and I am going to appeal, but I'm not very optimistic, to be honest with you, about how it's going to be perceived. I think I'm right on the law, but I think what I have learned so far in life is that being right is not necessarily going to, you don't win because you're right. You win because of many other factors. And if you're right, it's a cherry on top of the cake, but it's not the cake, So yeah, so we're going to go through the motions, and we're going to do what we can, and we're going to take it as far as we can. Even if I have to go to the Supreme Court of the United States, if they will allow me, I will do it. because I believe that whether or not I'm a master or mistress of the ECF filing system, I believe that what I am saying is right. I believe that it is legally correct. I believe that it is morally correct. I am disappointed that the defendants, didn't respond. I wish they had shown, enough respect. But I guess they just took one look at my ECF filings and they're like, they're not even taking me seriously. And, they look at what the judge said in the motion and they're just like, So, whatever. I'm going to keep going as far as I can go. And I will stand for my principles. And we'll see what happens. So that's where we are with my case. Okay, that's where we are with my case. I wish the news was better, but I thought I should give you an update anyway. Okay, so I'll keep you posted in another few weeks after I hear back from the appeal to the Second Circuit. And we'll take it from there, because I've always sort of felt that I would have to go to the Supreme Court anyway, and the Supreme Court is not obliged to say yes, but certainly if necessary, I will go through the motions and I will seek assistance from the Supreme Court if I can get it. If the Second Circuit, turns me down. So I'll keep you posted. All right. So thanks for listening. Take care. Bye.